Good day and welcome to Wessels Vlogs. Today I would like to discuss with you some new literature regarding the EU Insolvency Regulation 2015, sometimes known as the Regulation Recast. You know, the original regulation came into force in 2002. In that time, lots of literature was published. A second generation of literature relates to the new regulation, the one from 2015. Literature includes Borg-Mangano book, the third edition of the book that was edited by Gabriel Moss, Stuart Isaacs and Ian Fletcher, and a little bit later the book of Borg van Zwieten. These books were the first one to deal with the regulation, sometimes only in themes, later more in article by article commentaries. Now the second generation comes into the limelight. For instance, especially for non-European readers, it's a little book from the American Bankruptcy Institute. By the way, all the information on the books you will see on my blog. I will refer to that later. The American Bankruptcy Institute book, which is the fourth edition of my book, this time together with Ilya Kokorin, on an introductory analysis of the European Union regulation on insolvency. The two books I would like to discuss with you very shortly today is the book from Professor Brinkmann from the University of Bonn and some 15 authors called Article Commentary European Insolvency Regulation. And the other book, in fact, two parts of one title, is the book of Professor Alexander Bělohlávek, I hope I pronounce his name well, and that's also a commentary on the insolvency regulation. Well, the two books are written for the same audiences, especially practitioners, judges, scholars, sometimes also, I would guess, legislators. They divert a bit in the targeting audience. First, on the authors themselves, as I said, there are 15 roughly German authors writing in English. Mr. Bělohlávek is the sole author of these large books, and therefore they roughly miss the idea of writing with several authors from several jurisdictions in especially the Borg van Zwieten book. And by the way, the Borg van Zwieten book will be published in the second edition. I think it will be the first half of 2021. The structure of the book, just go to, for instance, Article 8 with regard to the protection of right in rem. There, in Brinkmann, the text is rather direct. You have the text, the recitals, specific biography, two sources, Court of Justice of the European Union case law, 3 cases, and the German Bundesgerichtshof, the Federal Court of Germany cases, in all some 6 or 7 pages and 31 footnotes. The Bělohlávek book is much more broad. There's the text of the regulation, of course, and there is also the text of the nearly similar provision in the original regulation as a detailed reference also to the recitals, also to other EU law, for instance the Rome regulation, Rome I regulation, and other international conventions. As to European court cases, The 5 I mentioned, also 2 cases that are indirectly related to Article 8, and from the member states, court cases are referred to from Austria, Germany, France, Hungary, 2 from Luxembourg and 1 from Malta. There are 4 pages of literature references, including Italian, Czech, German and Austrian legislation. So here you will see in some 30 pages and 127 footnotes a tremendous, deep and broad treatment of Article 8. That doesn't surprise, because the Bělohlávek book, the 2 parts, is roughly 3 times the size of the book of Brinkmann. If you go to Brinkmann again, there's no list or index of the Court of Justice of the European Union cases. It does refer to soft law, the COCO guidelines, and the Judge Code guidelines. It refers to my own book. I would like to show you which are these 2 books. On international insolvency law, they're based on my series, the Dutch series Insolventierecht, written by me, but the last 2 parts in the series are written in English. So part 1, global insolvency, part 2, mainly the European insolvency regulation. That book is from 2017. Brinkmann, however, refers to still to 2012, but for new concepts in the regulation recast, Article 36 has these new rules with regard to the undertaking. 30 pages from Laukerman. It does not refer to my part 2 from 2017, but in the treatment of groups of insolvency, some 90 pages in Brinkmann and 230 pages in the Bělohlávek books. In the groups of companies, Sparlinger and Skauratsun, the German authors, refer to my part 2. Regarding the Bělohlávek book, it does have an extended list of European court cases. It does not refer to soft law, only to the Judge Code guidelines in the large part on groups. It does not refer to my part 2 from 2017. It also does not refer to the book from Moss, Fletcher Isaacs, and the Borg van Zwieten book, but it does to Borg Mangano. What's valuable in Bělohlávek parts is the national languages, translations of words like establishment or protocol. You see that those translations differ quite tremendously. There are copious references to literature and other sources. It's very broad, although the final year there sometimes seems to be 2016, sometimes 2017, and for German language literature it may be 2018. There are great indexes with regard to where to find case law and references of articles in commentaries on the other articles. So there's an internal reference system if you would go to the books. In all, I think both books, the Brinkmann book, which is from Beck, Hart and Nomos, and the Bělohlávek 2 parts of the book, the publisher you will find on my blog. In all are valuable books for the legal practice, although I would think that scholars would like a bit more the Bělohlávek book because of the broad sources. I think both books are a welcome addition for the slowly growing body of literature, now also to the literature with regard to the recast of the EU insolvency regulation. Well, thank you very much for your attention, and I hope to see you next time.